How can you win at trial and still lose? I'll tell you how in just a moment. Well, the cold Arctic winds are blowing here in Alabama today, and it's colder than a politician's heart in my house at the moment. So I have on a sweatshirt. I hope those of you who have gotten used to the red shirt will forgive me here. Tony DeWitt here, Missouri appellate attorney, and a guy who likes to make the law make sense on YouTube. So today we're going to try to make sense of some procedural issues that sometimes come up. Now, one of the many terms you've probably heard in court cases is due process. And there are two types of due process. Substantive due process relates to the substance of justice administered by the court, whether or not the judgment itself actually conforms to due process. And then there's procedural due process. Now, substantive due process is a relatively old Supreme Court doctrine that rarely raises its head these days, but procedural due process is quite another. Courts look to make sure that the procedure was followed and that courts, through their rulemaking, make rules that ensure that the parties' rights are protected. Some of those rules come up in motions, and there are certain motions in a case that are not dispositive. For example, a motion in limine is used to ask a court to make a determination about the admissibility of a particular piece of evidence. Other motions are dispositive, and what that means is they terminate the case and one side or the other is declared a winner. Now, the first of these is a motion to dismiss, and that is potentially dispositive. You file a motion for dismissal when you think that there are legal problems with the claim. And then there's a motion for judgment on the pleadings that I discussed a few weeks ago. That also is dispositive, and it also asks the court to make a determination, a legal determination, that the plaintiff doesn't have a case here. And then there's a motion for summary judgment. That's also dispositive. That occurs later in the case, after discovery and after everybody's had an opportunity to evaluate their claims, make any amendments to petitions, that sort of thing. In each of these motions, the goal is to prevent the case from being heard by a jury. As I mentioned earlier, summary judgment says we know the facts, these are not in dispute, and based on these facts, we want a ruling. You see this a lot in contract cases and in insurance cases. Once you get past summary judgment, in other words, once the defendant loses at summary judgment and the court said, no, there's factual issues, we need to take this to trial, then you're going to go to trial and there's evidence that's going to be presented, and there will be witnesses who come in and make testimony or give testimony. Let's take a look at a motion for a directed verdict. Now, a motion for a directed verdict simply says that the plaintiff, or in some cases the counterclaimant, or if you're in a criminal case, the state, has not made a submissible case. And a submissible case is made when the plaintiff proves up all of the elements of a cause of action. Let's take an action like negligence. In a negligence case, the plaintiff has to prove that the defendant had a duty to the plaintiff. They have to prove that that duty was breached and that the breach caused, or at least if it didn't directly cause, it contributed to the plaintiff's damages. If the proof on one of those elements is lacking, then a directed verdict is proper. Sometimes a directed verdict is even proper before a single piece of evidence is offered. Opening statement is used to lay out the case, what the plaintiff believes the evidence will be. And they have to hit all of those elements. This is not evidence, but it lays out the evidence to be presented. If during opening the plaintiff fails to address an element of the case, if it fails to say, well, this is what the evidence is going to be on causation, or this is what the evidence is going to be on duty, well, you've lost, and the directed verdict is proper. But the most common time when a motion for directed verdict is made is when the plaintiff, or the state in a criminal case, rests their case. But only if there is a complete absence of facts establishing an element is the motion properly granted. In other words, if for whatever reason the plaintiff did not make a showing that the actions of the defendant caused or directly contributed to cause the damages of the plaintiff, then if they didn't do that, if they didn't make that showing, then a directed verdict would be proper. This is not a situation where contrary evidence applies. In other words, you don't get to say, if you're the defendant, you don't get to say, well, we have evidence that shows that that never happened, so directed verdict should be proper. That's not it. As long as the evidence was admitted that establishes the element, it doesn't matter what the contrary evidence is. So only if there is a complete absence of facts establishing an element is the motion properly granted. If you don't make the motion, and you certainly don't have to, then you are effectively conceding that the plaintiff, or the state, made a prima facie case. In other words, they hit all of the elements. So pretty much every lawyer who's a defense lawyer makes that motion. Now, less than 1% of motions for directed verdict are granted. This is because, having gotten to the point of trial, the preference is for a decision on the merits by a jury. That's why we have the jury system. So the court usually denies the motion even if the evidence is thin. And then the defendant puts on their case, as I said, and then once the defense rests, the plaintiff finishes any rebuttal, the motion for the directed verdict is made again. And again, usually that motion is denied because the jury is allowed to speak on the issues involved. But here is an important point. If you don't make the motion at the close of the evidence, like I said, not only is there an issue of waiver as to the concession that there's a prima facie case, but it avoids your ability to make another motion later on, which we'll get to here in just a second. So it's, even if you think the plaintiff hit all of the marks, you still make the motion because there were 4 acquittals at Nuremberg. You never know what's going to happen. So the jury's instructed and they're sent to the jury room to determine whether the plaintiff will recover or the state, if the state has convicted, and they reach a verdict. If the jury comes back and says, no, I'm sorry, the plaintiff did not make their case, and issues a judgment for the defendant, that motion, the directed verdict motion, is of no consequence. But if the plaintiff wins, that directed verdict motion and the rationale that was used to support it looms very large, because there is one more final Hail Mary pass that the defendant can attempt to complete to escape liability. And that is called the Judgment Notwithstanding the Verdicto, or more plainly in English, the Judgment Notwithstanding the Verdict. Now, it's sometimes confusing because lawyers talk about verdicts and judgments, and they sometimes conflate the two. They are not the same thing. The verdict is the form that the jury brings back. It states their findings. We find for the plaintiff and we award $10,000. The judgment is the order entered by the court on that verdict. Now, here is an example of a court entering a judgment on the verdict. So you can see the difference between the verdict and the judgment in this little clip from the Kerchevsky trial.
The state would request entry of judgment on the verdicts.
Anything from the defense?
We'll reserve any argument for later.
All right, thank you. Court will enter judgments of convictions as to all 3 counts.
So the jury finds all the elements, awards $10,000. The next motion that the defendant is going to make, and they'll probably make it along with a motion for new trial, is a motion for JNOV, or Judgment Notwithstanding the Verdict. And they point to the directed verdict motion and show how the elements were not proved and ask the court to enter a judgment notwithstanding the verdict. The motion effectively annuls the jury verdict, and for that reason, it's entered very, very seldom. To be proper, there has to be a complete absence of facts on an element of the case, and if there is, then JNOV is proper. And we can look to a Missouri case called Moore versus City of Park Hills as a good example of a case involving a JNOV and whether or not it was actually appropriate. The plaintiffs there were a husband and a wife who purchased a lot on Mill Street in Park Hills, Missouri. And they put a mobile home there, and they put a 40-foot trailer on the property. So the plaintiffs planned to use the trailer as a permanent storage area for the personal property. In the spring of 1994, plaintiffs began moving some of their personal property from the house they were renting in Park Hills to the trailer on Mill Street. Plaintiffs testified that the items placed in the trailer were not packed for moving because they didn't expect the trailer to be moved. They were going to use it as a permanent storage building. They said, roughly 40% of their personal property was stored in that trailer by May 12, 1994. So on May 12, 1994, the defendant, one of the defendants, Officer James Pope, who was the environmental enforcement officer for the city of Park Hills, was contacted by the chief of police there. And the chief of police said, we've got this trailer, and he said that he'd received numerous complaints regarding the trailer and the Mill Street property, and that he was declaring the 40-foot trailer a nuisance under the city ordinance. Now, the police chief told Officer Pope to go to the Mill Street property and tow the trailer. At trial, the chief stated that he didn't expect Officer Pope to give the plaintiffs notice before he towed their trailer. Why that is, I'm not exactly sure, but you're entitled to notice before the state seizes your property. Although Officer Pope knew the plaintiffs lived on a nearby street, he didn't make any attempt to notify them that he was going to tow their trailer. He was aware that the trailer contained personal property. He testified on May 12th that he operated under the belief that the city ordinance allowed him to tow vehicles from private property without notice, and that he had previously towed unlicensed vehicles from private property. He testified that he was carrying out the policy of the defendant's city of Park Hills when he had the trailer towed off of the plaintiff's property on Mill Street. On May 13th, the day after the trailer had been towed, the plaintiffs discovered that their trailer was missing. That must have been quite a surprise to them. So they did what any person would do in that situation. They called the police to report it as stolen. And they were said, no, the city of Park Hills removed your trailer. The plaintiffs made approximately 4 demands for the return of the trailer and its contents. And in June of 1994, the plaintiffs were allowed to inspect the contents of the trailer, and a video was made to record the condition of the property at that time. A lot of their items of personal property suffered damage as a result of towing the trailer from Mill Street. Finally, the plaintiffs were allowed to regain possession of the trailer in July of 1994, or roughly 2 months after it was towed. So they did what people do in that situation when the government acts rashly. They sued under Section 42 United States Code, Section 1983. And after a trial, the jury returned a verdict for actual damages in favor of the plaintiffs and against the defendant city of Park Hills, and a verdict for actual damages and punitive damages in favor of the plaintiffs and against defendant Officer Pope. After trial, the trial court granted defendant's motion for judgment notwithstanding the verdict. The Court of Appeals was not amused. Hey folks, please excuse the interruption, but let me ask you if you would, if you haven't already, please subscribe, and if you would, hit that like button and maybe even leave a comment. That tells YouTube that this is a valuable video and they'll refer it to more people. It helps me out a lot and I appreciate it. Thank you. Court said the judgment notwithstanding the verdict is a drastic action and it should be granted only when reasonable persons would not differ on the disposition of the case. So when they looked at this, they're reviewing the entry of judgment notwithstanding the verdict. They look only at the evidence and reasonable inferences favorable to the jury verdict, and they disregard any contrary evidence that doesn't support the verdict. A defendant's motion for judgment withstanding the verdict should never be granted except when the plaintiff failed to make a submissible case. And in the Moore versus City of Park Hills case, the court found that there were no exigent circumstances that necessitated the immediate removal of the trailer. Now, an exigent circumstance would be something like, it was on top of a gas main or blocking a fire hydrant or something like that, parked in a no parking zone. The court even said it was not parked in a no parking zone or blocking a roadway. Rather, it was parked on private property. In the absence of an emergency, and there was no showing of an emergency here, the existence of a subsequent hearing will not satisfy due process requirements. So essentially what the plaintiff pleaded here was their due process rights were violated, and the court found that their rights were violated, and as a result they said The judgment notwithstanding the verdict was improper, and they reversed it and remanded it for entry of judgment consistent with the verdict. So even after you have won in a case like this, it is still possible to lose. And that's essentially what happened here. So if you have any questions, please feel free to leave them in the comments down below. Like, share, subscribe, all the stuff we ask you to do. If you have the opportunity today, go out of your way to be nice and be kind to people. Sometimes even when people leave mean comments, I try to be nice to them. Sometimes even when they're really ugly, I try to be nice to them. Just because being ugly to them is probably not going to make them any different. So I just take the high road. Hopefully you will too. Have a great day today, and be kind, be thoughtful. If you get the chance, do something nice, and catch me back here at the beach tomorrow. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.